it's going to be hard to get out because normally they don't put bail on federal cases. So there's not a bail amount. You're either released or you're not released on it, on setting security on things. It depends on the charges, obviously, at times on whether a bail amount or you could be released on these types of cases. And then once you're in custody, then you'll have the arraignment, where you'll have the official charges that they're charging you with. You may think it's just one or two incidences, but what normally happens is that between the time of your initial appearance and the arraignment, they've gone back and done some digging, and they may have pulled up 2 or 3 or 4 or 5 years of worth of information that you have not filed correctly or made the same misrepresentation, or they go back and they just start digging and they charge 10, 15, 20 counts. It could be as many as that.
Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode. Good morning, Shanon Gray.
Good morning.
How are you?
Good. Doing great. Thanks for having me.
Of course. Well, it's my pleasure. I want to introduce you, Shanon Gray. First and foremost, I would feel like is a good friend of mine. We have known each other now for over, 24-ish years.
About right. Yep.
Which is a long time to know someone.
Old dogs here, a couple old dogs.
That's right. We actually met while taking the bar exam, if I remember correctly.
That's correct, yeah.
During a break, and sort of stayed in touch off and on throughout the years. And Shanon is currently a criminal defense attorney. Has been a criminal defense attorney for a big chunk of your career. In my opinion, one of the best of the best. You're licensed in Oregon and Idaho, have represented people from misdemeanors to felonies to the most serious of crimes, both at city, county, and then the federal level. And, even a little bit famous and makes the news from time to time and gets interviewed. And so I always like to tease you about that. And then just an amazing criminal defense attorney. So if you're ever in need, and hopefully our listeners are never in need, but if you're ever in need of a good criminal defense attorney or a great criminal defense attorney, I always say call Shanon Gray. So thank you for giving me your time today. I appreciate it.
High praises from a guy I met in the parking lot.
Well, one of the reasons I wanted to interview you today is because you and I did a case together, and we've done some work together in the past. And one of the cases we did was a criminal defense case of Social Security fraud, where the Social Security Administration, through the Department of Justice, I believe it was, had arrested a client who became a mutual client of ours and charged him with, I believe, was Social Security fraud and theft of government funds. And I thought, just sort of to talk about that topic, to enlighten our listeners, I think from a criminal defense attorney, which is if you get charged with those two crimes, sort of your perspective of, what are things, and you and I can talk about it both, but what are things that people do to get charged with that? And then what does it look like post getting charged, arrested, and walking through the criminal justice system?
Well, a lot of these things, they'll start off a lot of times locally, right? You'll get a referral. Most of these times, you don't have a Social Security agency or an FBI, or normally that's just going after an individual person. A lot of times what will happen is that you'll maybe make some misrepresentations or omissions or false statements on something, maybe some local agencies that you're getting food stamps from, a TAMP or a SNAP or something along those lines. And then there's a local prosecution that may end up occurring, which would be a circuit court. And then a lot of times they'll kick that over to the feds. Now, when it gets to the feds, it's a whole new ball of wax. I mean, they can go back for years because, what normally the circuit courts are focused on are these, once or twice that you made a false statement or omission or a misrepresentation. And those can, you can, all types of things as far as misrepresentations and false statements. You might leave out something, you might forget to put something in, you might forget to check a box, and you continually don't check that box. And it may be just on an initial application, and then they just send you follow-ups, right? And on that initial application, you didn't check the box. And then on the follow-ups is all the information the same as it was, and you continually say yes to it. And that's really where you get into trouble in those things, is that you end up making false representations without knowing it, because you made a false representation or omission or something on the first application for those things. So where they start at is really where it begins. And then once you get into the federal process, it gets pretty intense. So
yeah. So one of the things, and we'll talk about the case we did, and then sort of part of this is resources, right? Like you said, Social Security uses Office of General Counsel, the Department of Justice, to have as an investigating force. It's not like Social Security has their own police department that is going out to kind of investigate crime. I think the two most popular, or the two areas where people are more likely to be arrested or to face criminal charges are if you are lying about working and getting paid under the table while collecting your Social Security disability benefits, because it is and they send you paperwork. And the problem with Social Security is they send volumes and volumes of paperwork that I don't think most people read. But right. In that paperwork, it explicitly says if you're disabled and you go back to work, you have an affirmative duty, meaning it's on the client's duty to inform Social Security they went back to work. And so some people will miss that, or some people will read it and be like, well, I'm going to work under the table and get paid, double dip both my income and Social Security money, right? And they can do that for years and years and years. And and Social Security, if you just Google Social Security fraud, one of the first things that will come up is the 1-800 number to report it. So if you have a neighbor, a relative, ex-wife, current wife, former friend that has a falling out that knows what you're doing and they report you to this 1-800 number, that Social Security is likely to investigate it and take action on it. So that's the number one. Like, you're hiding money while working and trying to collect Social Security because, maybe you don't know because you specialize in criminal defense, but the definition of being disabled and how Social Security defines people disabled is that you are able, you're not physically and or mentally able to work over what they call substantial gainful activity. So that's number one. The second biggest one I see people getting arrested for Social Security is that in Social Security fraud cases is that someone dies and then they don't report it and they're still collecting on that deceased person's check. So, but in our case that we did together, it was more the first one where someone was working under the table. They tried to say, hey, look, I didn't know, and worked for years and years and years. and the person's ended up getting separated from their wife, and then that wife reported him to Social Security, and then unfortunately this person was charged with Social Security fraud and theft of government funds. What happens, Shanon, then at the criminal level once it goes to the feds? The person gets arrested. Maybe just walk our listeners through just generally in federal court what it looks like if you're arrested for Social Security fraud and or theft of government funds or whatever they charge you with.
Well, normally they'll do, especially in federal cases, they'll come out. I mean, they'll come out and kick the door in, and they make you an example a lot of times, or they'll arrest you at your employer, or they'll arrest, they try to make people an example of things when they are arresting them. And it'll be federal agencies, FBI, U.S. Marshals, somewhere along those lines will do the arrest. And once you get arrested, you'll be taken into custody. After you're taken into custody, you'll have an initial kind of a release hearing that happens normally within 48 hours, depending on what the date is. If you're arrested on a Friday, it won't happen until Monday. But it's normally within 48 hours, you'll have a release hearing initially. And that release hearing will tell them whether or not you're going to be released out to the public or you're a danger to yourself, society. There's a lot of other little factors that they take into play, whether you're going to continue to do what you were doing. And they'll either release you or keep you in custody. If they keep you in custody, it's going to be hard to get out because normally they don't put bail on federal cases. So there's not a bail amount. You're either released or you're not released on it, on setting security on things. It depends on the charges, obviously, at times on whether a bail amount or you could be released on these types of cases. And then once you're in custody, then you'll have the arraignment, where you'll have the official charges that they're charging you with. You may think it's just one or two incidences, but what normally happens is that between the time of your initial appearance and the arraignment, they've gone back and done some digging, and they may have pulled up 2 or 3 or 4 or 5 years of worth of information that you have not filed correctly or made the same misrepresentation, or they go back and they just start digging and they charge 10, 15, 20 counts. It could be as many as that on it. And then once you're arraigned on the charge, you either hire a privately retained attorney or you get a court-appointed attorney. And, in our case, that's just it. When someone's on Social Security or they're receiving TAMP or SNAP or any kind of, they normally can't afford a privately retained attorney. Ours was an exception. And so, and also when it comes to that, is that you don't have the resources to fight the federal government, to hire your own investigator, to do the things that you need to do to try to mitigate the damages that you have to have. You have to rely on a public defender. Not that the federal public defenders don't do a great job. They really do. They handle a lot of these types of cases, but you are lumped into a caseload of hundreds of cases that they'll have. So you'll get the arraignment on it. You'll get a public defender. You'll get the discovery on the case, which that's the big thing in federal court.
Let me ask you a question. So just a little bit for our listeners. So a privately retained attorney that you have to pay cash for out of pocket, right? What's the typical caseload of a privately retained attorney?
A long time ago, when I first started, a buddy of mine who did privately retained work, really great, Mike Starpoli was his name, really great defense attorney. He gave me a legal pad and he said, every other line on the legal pad, you fill in a case. If it gets more than one page, it's probably too much. And so that ends up to be about 15 to 20 cases that a privately retained attorney is working at one point in time. Sometimes it's less than that. Sometimes it's 5 or 6 because they might be intensive cases. They might be stuff that's, rape cases, sex abuse cases, federal drug crimes where you have enormous amounts of evidence that's being presented that you have to go through. Wiretaps, phone calls. In our case, there was a ton of discovery, boxes and boxes of, like Peter said, statements that no one read, right? That kept sending to you monthly or weekly, and then once something happened, they send it even more and more, and you just kind of ignore them. It's kind of like your insurance policy, right? You they send you a modification to your insurance policy, and it's this big, thick envelope, and you open it up, and it says, we changed these 3 things, and here's what we changed. No longer if you hit a dog, is it covered, right? These kind of things, but no one reads them. They just say, but you still have coverage, and then you just toss it to the side. Right. But then when you go out and you hit a dog, then you find out that you didn't have any coverage, and they say, well, we told you, we sent it to you. So
right. I think it's a good distinction with, and just bringing it back to the privately retained, you have, like you said, 15 to 20 clients, you can just be really focused on those cases. Where if you do get assigned a public defender, and you and I both have worked for government agencies, and I forgot to mention this in your introduction, but you work for the DA's office prosecuting cases, and I was a public defender at the beginning of my career defending cases, and I had a caseload of 130 to 150 cases that I was asked to cover, and I think I'm a 26-year-old kid walking in trying to cover all these cases. And that's where it can get rough. And like you said, people on TANF, which is, state assistance or food stamps or Social Security, may not be able to afford a privately retained. So then you're with the public defender, and then they get volumes. And the federal public defender's office, in my opinion, is great. So I don't want to belittle what they do. They do have a bigger caseload than, let's say, a guy like you, privately retained. And so, and then then they go to the arraignment, which is typically 99% of the people, if not 100% of the people, plead not guilty at that point.
Yep.
Correct. And then you get this discovery. And the discovery, what does that mean for people who are not familiar with the criminal justice system?
Well, it would be all the police reports, investigative reports, anything that the prosecution has that they're going to use to prosecute your case. So it could be all of those notices that they sent. It could be statements from witnesses that they have interviewed along the way. It could be the person, Uncle Joe, who can't stand you, who's the one that reported you. It could be a statement from him. That is just it, is that, especially in this area of law, the Social Security fraud and those types of things, 90% of those are initiated by a family member or a relative or an ex-wife or girlfriend, whatever it is, because they know the ins and outs of your personal life. They know what you're doing. And so all it takes is one of those people to turn on you and start the process and the investigative process, and then they give all the details. In our case, Peter was, the woman, it was an ex-husband and a wife, and it was the relationship between the two that got distraught, and then they started going after each other, and then it ended up being a federal case. So, remember, those are the people that normally initiate these types of cases, because like we said, the government's not actively going out and looking for Social Security fraud. They're taking you for your word when you fill out those forms. Because they have all of these warnings on those forms that say, hey, if you lie to us, we'll prosecute you. And so,
Yeah, which is why I think it, on some levels, when it does happen, if a person is arrested or is charged with this crime, just like you said, they're not proactively, it doesn't feel like they're proactively going out to arrest people or investigate it. They just don't have the resources for it. But so much time has passed that this fraud has continued. So now it's just this gigantic case.
Yep.
Because it's not just this little case that he committed fraud last week and we caught him. It's been going on for years, and then there was a falling out with the person, and then it gets reported, and now there's this 15 years worth of discovery, 15 years worth of fraud, and I don't want to jump too far ahead to the sentencing of it all, but so then after arraignment, what does that process look like? Discovery, you go through that, then what happens?
Yeah, you go through the discovery, you try to figure out because really it's normally a couple of facts. It's not you lied on everything all over the place. It's normally one or two areas where they're attacking you on, right? And so you try to look at those, and then what were the fact patterns surrounding those things, right? was a child living with you at the time and you reported it wrong or incorrectly, or was there custody that was shared, or were you working just a little bit but not enough to have to report it, right? Or whatever it is, you try to look at those small fact patterns, and you have to meet with the client and you have to dig deep with them. You say, hey, and that's difficult in itself, in that, what were you doing in March of 2019?
Right.
When you reported this? I was living with such and such, and I think that's what it was. Well, do you have any receipts or anything like that? Or is that, any of that information that you can supply? Because you're not only going through the discovery to try to defend the case, you're going through the discovery to mitigate the case. Because, a lot of this stuff is factual. It's hard to defend at times because they gave you that 4-page notice that you signed at the bottom that said, is this information correct? And you said yes. And then like we said, it repeats every month. You sign the notice again, right? Even though circumstances changed in some way. So all they really have to do is really prove that the circumstances changed. And you have to try to defend, well, this is the reason why, right? And really what you're left with is, even in our case, was, do they believe you or not? Does the jury believe you made a mistake, or did you not make a mistake? Was it willful, intentional, and you meant to get these benefits, extra benefits and extra money? And sometimes just by knowing that your check went up without knowing the reason why is alarm bells, right? I normally get $500 a month, and now I get $650. What? And you just continue to take the $650, right? Well, you're knowingly and willfully, and you might be engaging in Social Security fraud, right? Because you don't know why that happened, right? So there's a lot of aspects of this that it comes back and bites you in the rear end. So
right. Let me ask you this: after you've gone through discovery, you've met with your client, what are the options typically of a criminal defendant in federal court, in federal cases? Are they looking at trial, for example? What are those type of options?
You really have two options. You can either negotiate the case or you can take it to trial, right? Those are the things. And so I'm constantly negotiating the case. Like, I'm constantly from the get-go. As soon as you receive discovery, you're in contact with the federal prosecutor. You're talking with them about facts of the case. Because remember, they have a caseload as well, right? They have an intense caseload that they may have hundreds of cases as well ongoing. And so you have to factually look at what you can do to get a lesser charge, less penalties, less fines, anything like that as you're working on them. And then ultimately you come to a resolution and you say, hey, client, this is the best that I think we can get. Do you want to take it? If not, we go to trial. And if we go to trial on it, this is what you might be subject to. You could be found not guilty on everything if they believe our testimony and they believe the evidence that we're going to present, or you could be found guilty of these charges but not these charges, or you could be found guilty of all the charges, and then you go through basically what the with the prison, jail time, whatever it might be, fines and fees are you could end up with. And so but you're constantly, and trial in federal cases are rare. And why is that? Is because they have unlimited resources. Meaning
the prosecutor.
The prosecutor. I mean, I can tell you this, going to federal trial, I work by myself. I do my own stuff because I'm a little bit of a control freak. And so I like to file my own motions. I like to do everything that I need to do, get everything together for trial. But when you walk into a federal court trial, it'll be myself and my client, and then you'll look on the opposite side, and there may be 4 or 5 people sitting there. There may be the prosecutor, an assistant prosecutor. They have a discovery clerk that's managing the discovery. They have a witness clerk that may be handling the witnesses. And then they may have 2 or 3 investigators that are sitting in the background waiting to go investigate something that's one of your witnesses testified about, and they can track it down. So not only is that the case, but also there's the discovery aspect of it. You may have to go through hundreds and hundreds of pages, thousands of pages and documents and phone calls and forms and all of these things organized for trial. It's incredibly intensive. and then your witnesses. And then federal court you have a federal judge, which aren't the easiest.
They're appointed by the executive branch for typically for life.
That's right. And they know they're on there for life. So, it can be a difficult trial in itself, unlike a circuit court case, because there's a lot of latitude that you get in trying a case in circuit court. Right. Motions and voir dire and direct and cross-examinations and all of these things that can be fairly broad, and closing arguments and all these things. In federal court, voir dire is very limited. It's limited by the judge. And so you don't really get a chance I don't really feel like you get a chance to really get a fair and impartial jury.
Not like a circuit court voir dire. And circuit court, you're meaning like local, state and county, city, whatever it may be.
You still have the same jury pool that you're pulling from. But what happens is that in circuit court, I can ask, my voir dire might last a half a day, a full day, a couple of days, depending on what type of case it is. But in a federal court, it might last 30 minutes. You have to submit your questions ahead of time to the judge on what you think you'd like to ask the jury. He'll ask those questions. You don't get to dig as deep, and then it's over with. The jury's seated. So it's a tough haul when it comes to trying to pick the best jury that you want for your client. So you have the trial, so you can have a trial and you have all of this stuff that's going on with it. But motions, pretrial motions within the case, direct examination of witnesses, cross-examination of witnesses, your opening statement, your closing statement, you have all of these things that go into it. So
if I remember correctly, and correct me if I'm wrong, the case we did together, and I don't want to go into too much detail about it, but the case that we did together, I think from start, meaning from the day we kind of knew the person got arrested to arraignment and I think we pled guilty. We ended up advising to plead guilty, and the client wanted to. Was about 6 months. Does that seem right, or was it shorter than that, or longer than that? Do you recall?
I felt like it might have been a little bit longer because he might have done.